Hi, Assalamualaikum Dr. Wazana. My name is SHANUR Fazleenda binti Anuar. Today I'm going to present to you about the cases that my group already chose, which is SHEIKH ABDULLAH Ahmad versus Universal Music Senda Berhad. In that cases, the counsel for the plaintiff is Ms. Zupaidli and Idham, where the defendant is Ms. On and the partners. So, for these cases, the plaintiff is a singer and had been active in the entertainment business since 1980 century, where the defendant is a company incorporated in Malaysia and is involved in recording business. So, I will explain the introduction of the cases where the plaintiff and the defendant were using the animation video. So, let's watch the video first.
Hi, I'm SHANUR. I will explain the introduction of the cases SHEIKH ABDULLAH Ahmad versus Universal Music Senda Berhad, were in High Court Malaya, Kuala Lumpur in 30 March 2017. In these cases, the plaintiff was a singer and had been active in the entertainment business since the 1980s century, where the defendant is Nawab Productions Senda Berhad, that was a company incorporated in Malaysia and was involved in the recording business, where the defendant entered into a sale and purchase agreement in 2005. In 1983, the plaintiff had entered into a contractual relationship with a recording company, which is MRC. At that time, the plaintiff has produced an album which is Kau Bungaku. The plaintiff claims that the album was selling like hotcakes at that time, reaching sales of 100,000 units, and the plaintiff is entitled 20% royalty for the sale of each album. But the huge sales of the album in both LP and also cassette, MRC did not make any payment to the plaintiff. Therefore, the plaintiff did not continue with his contact with MRC, which had since closed down. The producer of the album is Ahmad Nawab, where he is on the copyright of the said album and entered into sale and purchase agreement 2005. On 30 November 2005, Nawab Productions Senda Berhad and Music Valley Senda Berhad entered into a sale and purchase agreement 2005, whereby Nawab Production reassigns the right in the album to Music Valley on a 60% and 40% ownership. Is the responsibility of the vendor. Nawab Production is to deal with the third-party liabilities, which would include the royalties due to the artist concerned, including the plaintiff. Therefore, Nawab Production should be solely responsible to pay to the artist from the payment made by Music Valley Senda Berhad, as the 2008 Novation Agreement merely transferred the rights and obligation of Music Valley Senda Berhad to the defendants, and that there are no changes made of the 2005 agreement. Any payments of royalty due to the artist are still made to Nawab Production, not to the artist directly. This can be seen from a letter issued by Nawab Production Senda Berhad dated on 25 February 2011, which directs that all royalties due to Nawab Production Senda Berhad will have to be paid to Ahmad Khan bin Nawab Khan. Under the term 2005 agreement and 2008 Novation Agreement, the plaintiff was only entitled to 8% royalty, not 20% as claimed by the plaintiff. And the plaintiff should have got a witness for Nawab Production to give evidence that the royalty is 20%, not 8%, because that event was only binding with MRC, not the defendant. In these cases, the plaintiff was claimed 20% royalty under the 1983 contract with MRC from the sale of each album or song. Added to that, the defendant was not a party to the 1983 contract. Thus, the defendant not liable to pay the plaintiff 20% royalty from the sale of the album because the plaintiff had failed to provide any evidence of the term of the 1983 contract with MRC. Plaintiff, in his evidence, says that he has no knowledge of the 2005 agreement or the 2008 Novation agreements. Around January 2005, when the plaintiff was in the country, he was informed that some of his songs from the album can be downloaded on the iTunes, which had been uploaded by the defendant. And upon checking the internet, he found out that the album can be downloaded from the iTunes at the price of $4.99. Plaintiff was signed the contract with MRC in 1983. But plaintiff filed this action in 2015. That means after more than 30 years, the plaintiff was taken action. He was very serious in his contention that he is entitled to 20% of the alleged 100,000 sales of the album. Thus, there was no breach of the plaintiff rights under Section 60A1D by defendant, as the defendant was not privy to the 1983
Hi, my name is Siti NURAMELINA binti Rahim. My matric number 194074, and I'm going to explain a little bit about the cases, and let's watch the animation.
Hi, I am Emelina. Let's watch the finding of the courts of Sheikh Abdullah Ahmad versus Universal Music Sendirian Berhad cases. The plaintiffs, which is the singer, claim against the defendant is premised on the following causes of action, which is contractual rights and statutory rights under the Copyright Act 1987. The defendant has admitted that they have signed the novation agreement dated 22nd December 2008 with Music Valley Sendirian Berhad, Nawak Productions Sendirian Berhad, and Nawak Publishing House Sendirian Berhad. Pursuant to the 2008 novation agreement, the defendant takes over the liabilities and obligations of Music Valley Sendirian Berhad. Pursuant to the 2008 novation agreement dated 22nd December 2008, the plaintiff submits that the defendant is liable to pay the plaintiff royalty payments for the album with effect from 22nd December 2008. The next issue is whether the royalty is 20% as contended by the plaintiff or 8% as contended by the defendant. It is found that the plaintiff has failed to prove the same. There is no documentary proof to support the contention apart from the oral evidence of the plaintiff and his brother. In any event, if the said 20% royalty was the agreed one, then it is only binding on the MRC, which was a party to the 1983 contract, not the defendant. Added to that, from the email dated 15 April 2015 from June Nawab, the defendant was informed that the defendant is to pay 8% royalty to the plaintiff on behalf of Nawab Production. Therefore, the party responsible to pay royalty to the plaintiff is still Nawab Production, not the defendant. Having considered the evidence, it is considered opinion that under the terms of the 2005 agreement and the 2008 novation agreement, the plaintiff is only entitled to 8% royalty and not 20% royalty as contended by the plaintiff. If the plaintiff disputes this figure, then he should have called a witness from Nawab Production to give evidence that the royalty is 20% and not 8%. In fact, in his evidence, he signed the 1983 contract with MRC on behalf of his brother, the plaintiff. In any event, the 20% royalty is only binding on the MRC, not the defendant. Added to that, the plaintiff did not take any action to enforce the 1983 contract against MRC, and neither did he institute any action against Music Valley or Nawab Production over the alleged 20% royalty. The plaintiff signed the contract with MRC in 1983, yet he only filed this action in 2015 after more than 30 years. Next, we move to the second finding of the courts, which is statutory right. The claim premised on statutory rights under the Copyright Act 1987. The plaintiff is seeking a declaration that the defendant has infringed his performance right under Section 36 of the Copyright Act 1987. Copyright is infringed by a person who does or causes any other person to do without the license of the owner of the copyright, an act the doing of which is controlled by copyright under this act. The defendant has submitted that under Section 7 of the Copyright Act 1987, the works that are eligible for copyrights are as follows. The first one is literary works, followed by musical works, artistic works, films, sound recordings, and broadcasts. In the present case, it is not in dispute that Ahmad Nawab owns the copyright to the album, as there is no evidence that the plaintiff is claiming ownership in respect to the literary, musical, or sound recordings of the album. The defendant submits that the plaintiff cannot claim for the infringement of copyright under Section 36(1) of the Copyright Act 1987. The plaintiff is seeking a declaration that he has performance right under Section 16A of the Copyright Act 1987. As such, the plaintiff now seeks for the damage for the defendant's breach of the plaintiff's performance right under Section. The second one is the plaintiff is entitled to the equitable remuneration under Section 16B of the Copyright Act 1987. Therefore, since the studio recording of the album is not a live performance, then the plaintiff claim premised on Section 16A_1D is without any legal basis.
Hello everyone, my name is ZIPENG and my matrix number is 19564. I want to talk about the regulation missions of the case of SHEIKH ABDULLAH Ahmed Research University Music and some of my own options. Article 6B copyright can apply a copyright to notes as determines the amount of equity payable. Regarding the injunction requested by the plaintiff, I will not grant because the plaintiff is only ask for the payment for the download of his album. In addition, the copyright of above album belong to the newborn production company, which is not disputed. According to the 2005 agreement, the Noble Production Company has granted music values the right of sales album, and the defendant has acquired the right to the album under the 2008 Innovation Agreement. In the end, the plaintiff has provided the reason for the royalties because the email from the Newton Production clear stated the defendant will directly pay 8%. According to the 2005 agreement, the Newton Production Company has granted music values the right of sales album, and the defendant has since acquired the right of the album under the 2008 Innovation Agreement. In the end, the plaintiff has provided its reason of the royalties because the email from the Newton Production clear stated for the defendant will directly pay 8% of royalties of the plaintiff for Newton Production. We learned that musicians and their works are protected by the copyright law in Malaysia. However, signing a recording or publishing agreement may have an important impact on their intellectual copyright, and artists should know this before signing the agreement. Only this claim one allowed of penalty to bear the cost. We learned that musician and their works are protected by the copyright law in Malaysia. However, signing a recording or publishing agreement may have an important impact on their intellectual property rights, and an artist should know this before signing the agreement. Only this claim was involved to the plaintiff to bear the costs.